Hello, everyone. Welcome to Health 180 with Carrie Fenn and Rogers TV and podcast. It's October 4, 2021. My name is Carrie Fenn, and this is part one of our two-part special, Recognizing Mental Health Day, focusing on consent and capacity. We want to help you learn more, so let's learn together. I'm joined by Andrew Felker and Amanda Abate. Welcome to our show.
Thank you.
Thank you.
Andrew, tell us about yourself. I know you're a friend of the show. What have you been up to? And what's work been like lately?
Well, work's been kind of crazy busy. Being a wills and estates lawyer in a pandemic is crazy busy. Lots of people planning, worried about things. I've seen friends become ill. So that's kept us very busy. And also people being home, I think a bit stir crazy and more fighting about wills and estates. So it's on many different fronts. It's been a busy 18 months. I'll be glad when it's over.
But if there's a time to ever put your affairs like in motion, it's now, isn't it?
Well, absolutely, Carrie. And as we're going to talk here about consent and capacity over the next half hour, it used to be you'd worry about that when you got to the end of life in your later years. But if COVID has taught us anything, it can strike quickly, and it can strike with great force. So really putting things off is not a wise choice. Get your affairs in order now while you've got your health.
Yes. Amanda, tell us about the work that you do at Ontario Shores.
Absolutely. So my name is Dr. Amanda Abate. I'm a psychiatrist at Ontario Shores, and I do primarily inpatient work. So working with patients who are having mental health crises to the point that they're requiring inpatient hospitalization. And I'm also a member of the brain stimulation clinic at Ontario Shores that provides repetitive transmagnetic stimulation and electroconvulsive therapy for patients that require it for their mental health conditions.
Andrew, what does capacity to consent means with regards to power of attorney? And how do you determine if someone does have capacity?
Well, really, Karen, there's two different kinds of situations. One has to do with your capacity to manage your money, your assets, your real estate. And the other one has to do with your capacity to manage your more personal affairs, where I'm going to live, what I'm going to eat, kind of treatment I'm going to get in the hospital, my end of life decisions. So the law kind of separates out the two, property and personal care. There's a statute, the Substitute Decisions Act. It kind of has a test. It says, here's the language, the test if somebody has the capacity. And I wrote it down so I didn't have to memorize it here. So a person is incapable of managing their property if they can't understand information that's relevant to making a decision about their property, or they can't see the reasonably foreseeable consequences of a decision or a lack of decision. So if they can't comprehend what a decision is going to do, if they don't understand that spending $1,000 when you have $10 in your bank account isn't a good idea, probably they don't have the capacity to manage their property. It's much the same for personal care. If they can't understand the information relevant to making a decision about their health care, about their nutrition, their shelter, their medical treatment, then they don't have the capacity to make the decision, and they need somebody else to make it on their behalf.
I am so glad you gave that definition and you read that, because I think a lot of people don't understand what that means. And I'm glad we have a psychiatrist, because when you say someone doesn't have the capacity, doctor, please fill us in here. What does that mean? Is that mental capacity? What does that mean? Please enlighten us.
Absolutely, happy to. And Andrew took a lot of the answer right out of my mouth, basically. But so when a treatment is proposed, so if someone's going through a mental health crisis, a patient or client is to be provided with the risks and benefits of treatment, the risks and benefits of lack of treatment, and reasonable alternatives to the treatment. And while that's happening, the provider should be assessing whether the patient is able to understand and appreciate the information provided. So like Andrew mentioned, and understanding is the ability to take in the information provided and comprehend it. And it's also important to point out that it's the responsibility of the provider to make sure any barriers to understanding are mitigated. So what that means is, let's say there's a language barrier, and so that's the reason the person is having difficulty understanding, then translation services should be brought in, because that's not a reasonable reason to say someone is unable to understand. They need to be provided with what they need to best allow them to understand. And then appreciation is about that ability to weigh the risks and benefits of the treatment being provided. And so when someone has a mental health condition, this can impair a person's judgment and ability to make decisions. And there is the possibility that they're not reasonably able to appreciate the consequences of their decision to accept or refuse the treatment proposed. So if that's the case, that if someone is unable to understand and or appreciate the information provided, they're considered incapable to consent to treatment.
And does that apply, the same thing apply to day-to-day life outside of treatment?
So as a psychiatrist and in the mental health system, I have very specific things I'm able to assess a person's capacity for. So I can make an assessment about whether they're able to understand and appreciate treatment. And I'm also assessing if there are any acute safety concerns related to that, related to their mental health condition. But I can't dictate where someone should live. I can assess that there is a financial capacity issue as well. But then in terms of someone deciding what should be happening with, say, a person's money after that fact or anything like that, a physician does not have the ability to do that. They can provide treatment recommendations to their substitute decision maker for treatment, and if someone is made incapable with respect to their finances, the public guardian or a power of attorney with respect to finances will make decisions at that point, keeping in mind the person's previous wishes if they're known. But I can't, I don't have overreach outside of treatment or making that assessment.
Yeah. Andrew, when you're in the process of signing a power of attorney with a client, what happens if you suspect that the person may not have the capacity to give you consent?
For me, it's they don't have the capacity to give me the instructions to understand what they're doing. So, I mean, I'm a lawyer. I'm good at drafting the legal things, and I have lots of training and I've done this a long time. But at the same time, I defer. I defer to doctors like Dr. Abate. I refer to a geriatric specialist, or we have people in Ontario called capacity assessors. So in that case, when I have a doubt, I would say to my client, look, I want this to stand up. And what I'm going to do is send you to somebody or have you go to somebody who knows what they're doing. They're good at doing the testing that goes along with capacity assessments. If it comes back and the person who's doing it, the assessor, the doctor, whoever, comes back and writes me a report and says, yes, Mr. Smith certainly has the capacity to grant a power of attorney, then I will do the document. And sometimes it doesn't happen. It happens maybe once a year that I have a client come in, and after spending a few minutes with them, I can tell that they're not capable of giving me the instructions. It's too late, unfortunately, in the process. So I just don't do it.
Yes. Dr. Abate, can you get consent from a person who can't give consent for medical care or treatment? Or how would that work?
So if a person is considered incapable to consent to treatment for a mental health condition, so if I've met with them and I have concerns about their ability to make that decision, I inform them of this, and then I complete what's called a Form 33, which is a form that notifies them of my finding of incapacity with respect to treatment. They're then contacted by a rights advisor through the Ontario government that will advise them of their opportunity to contest that finding. So if they choose not to contest, what will happen next is we will find a suitable substitute decision maker unless a power of attorney for personal care is already in place. If there's not a POA, we will go to the substitute decision maker. based on a hierarchy list that is stipulated in law. So there are different levels of that. So the first would be, say, a spouse or a parent, and then it would go down the list to sibling, et cetera, down the family line. If there is no one that can make that decision available, we would go to the public guardian and trustee to make that decision for the patient. If they do contest their finding, what will happen next is there will be a consent and capacity board, which is a hearing held where I or another psychiatrist would represent themselves. And the onus is on me to provide evidence about why I have concerns. And then the patient is represented by a lawyer. And during that time, I'm explaining exactly why I have concerns about this person's capacity. If the finding is not upheld, that would mean the person has the right to make their treatment decisions. If the finding is upheld, then we would go through the same process of finding an appropriate decision maker for the patient.
Andrew, how long does a power of attorney last for when you sign it? Is there an expiration date on it? Or does things change if somebody becomes, doesn't have their capacity?
Almost every power of attorney that is signed is considered a continuing power of attorney. And what that means is it continues past your incapacity. And that's what you really want. I mean, the real reason 99% of the time someone's granting a power of attorney is that they're thinking about the future when they're not going to be capable of making a decision. So as long as they say in their document, this is a continuing power of attorney, and you have authority, my attorney, to act during any of my incapacity in the future, it's good. It never expires. So we call those the magic words, but they're in basically every power of attorney that's done. The only exception is sometimes people will do a power of attorney to sell a piece of real estate if they're traveling. So perhaps they're going to be in Europe or Asia, and there's a real estate closing that's happening. They might give a time-limited power of attorney to a brother, a sister, a child, but that's a rare exception. The general reason for doing a power of attorney is to make it for the future. So you put those words in, this is a continuing power of attorney. It continues past my incapacity, and then it doesn't expire.
Is there any wiggling room if someone becomes sick in regards to signing one, or do you have to wait till the person's better before they can actually sign one?
Well, it depends on what you define as sick. If they are physically sick, if they've got the flu, they've got COVID, they've got something like that, as long as their mind is working and they've got the mental capacity, it can be signed. There's no reason that somebody who's physically sick. Now, if they're mentally not well and they have something has gone wrong, they might have something, a stroke, for example, where there's going to be potential recovery. It might be something some psychiatric condition where with medication and brilliant work at Ontario Shores, they're going to get back to a more healthy life. And at that point, when they're more healthy and they're capable, then they can grant that power of attorney. So the fact that somebody's not capable at this point in time doesn't mean that forever they're going to be incapable. Hopefully with treatment and medication, they'll become capable and can grant a power of attorney.
This is Health 180 with Carrie and Fenner Rogers TV on podcast. We're talking about consent and capacity. We'll be right back.
This program is brought to you by Ignite TV. Now you're in command. Visit Rogers.com for more details.
Hey, do you like movies? You know I do. That's why I see all of them. And if you want to know which ones you should see too, check out the latest Cinema Scene reviews and interviews. They're hot, fresh, and delicious, and they're online at rogerstv.com/cinemascene, popcorn not included. This offer is available everywhere. Tell your friends, be the first on your block to click rogerstv.com/cinemascene. It's so nice, we have to mention it twice.
You're watching Rogers TV.
Welcome back to Health 180 with Carrie and Fan and Rogers TVM podcast. My name is Carrie and Fan, and we are exploring consent and capacity with a panel of experts. Psychiatrist Dr. Amanda Abate and lawyer Andrew Felker joins us. Welcome back, guys. Interested in great conversation to have.
Thank you.
Dr. Abate, can you tell us what are some of the struggles someone who does not have capacity are faced with? And how can family members help them as they move forward in this pathway?
So generally, if someone's is found incapable to make treatment decisions, there's a high likelihood that they're having trouble making other decisions, likely related to a mental health condition that might be affecting, again, their ability to either understand the information or appreciate information and weigh risk and benefit. And so there's a likelihood that they're having difficulties in other areas of their lives. So finances, for example, and in worst case scenarios, they're having difficulty making decisions in terms of their safety. So they may be a risk to themselves, a risk to other people, or they may be having poor judgment in terms of their ability to care for themselves. So the first thing is to see if there is something that's what's considered an imminent risk, that they're an imminent risk to themselves or others. And if that's the situation, it's important to seek immediate medical attention. So bringing them to an emergency room or completing a Form 2 with the Justice of the Peace to bring them into hospital, contacting their care team if they have a care team already involved and letting them know that they need support, they need support and you need help to support them. If there isn't an imminent risk, it's important to consider what they want and what's going on. And so really it's just about being human and checking in, telling them you have concerns and seeing if they are identifying that as well. And if they are interested in help and want help. And you may have the opportunity, again, if there is a care team in place, otherwise to call the care team, let them know you're having concerns, speaking to other family members about it, and really just trying to support them in terms of getting the help they need. Now, one of the things I do also want to point out is that people have the right to be sick. So what that means is they may have a feeling of, someone may, for example, hear voices, but they don't have issues with capacity and they are able to understand and appreciate the benefits and risks of treatment and still choose not to have treatment. And that is their right. Having a mental health condition doesn't mean that they have to engage in treatment the way maybe their family or loved ones want them to. And that can be hard to experience as well. But it's important to note that we want to have people have their full rights as much as possible. And we're really only trying to intervene if there's a significant issue going on in that person's life and they want the help. If they don't want the help, then we're looking at if there's a significant risk. And that's why we're trying to intervene at that point. But people do have the right to be sick as well.
Andrew, at what age do you find that your client's power of attorney is used due to lack of capacity? Is there an age, or what have you noticed? Or
well, more typically, especially in years gone by, it's in later years. It's more people into their senior years, as things like Alzheimer's and dementia are far more prevalent. Certainly you're at more risk of a stroke later in life. And those are the three that principally will rob somebody of their capacity. But as we've seen, certainly in the last 18 months with COVID, COVID comes along and someone's on a ventilator and is quite ill, they may not have that capacity. It really depends on where they're at. So that might be much younger than somebody in their senior years. You know, you also have it where there's an accident, that somebody has a car accident or some other head injury that happens. So it can happen earlier in life. I mean, the majority of it is still with our senior clients, with people as they age and their body, ages. That's when they're far more at risk of having an episode or something that happens that takes their capacity away.
Dr. Abate, what kind of impact does it have on an individual if their capacity is being taken away when they're not ready, or if they feel they're not ready, or they might still have capacity?
Absolutely. So, I mean, it's incredibly distressing, and that's why there are checks and balances in the system as well. And also, again, why I'm really looking to see what are the risks and benefits of also making someone incapable. I'm also considering those risks, because it is a lot for someone to have that right to make a decision taken away from them. So in terms of what can happen in that way, and you mentioned what if they are in fact capable, that's why there are checks and balances. So if I find someone incapable, again, they're seen by a rights advisor and told of their options and their ability to contest that finding, if that's the case, to really fight for their right. And that's good. I want to have checks and balances and know that my assessment and judgment is held to a standard to make sure that it is what is right for the patient. But it is incredibly distressing to them. And so it's important to try and maintain a therapeutic relationship as much as possible, even if that's happening, and trying to find other ways to engage with the patient and try to find common ground about what they may be seeking and what we can work together on, while I'm also working to find appropriate treatment and working with their substitute decision maker or power of attorney to treat them effectively with whatever treatment is decided upon. The other thing I want to point out is capacity can fluctuate. So someone can be initially found incapable when they come in a mental health crisis, for example, and with treatment that maybe their substitute decision maker actually consented to on their behalf, their mental status will improve. That's always the goal. And they may then be able to make treatment decisions in the end. And so at some point, the decision making will go back to the patient. And that can change over time, that patients can have capacity and lose capacity. And it's also treatment specific. I can't determine that someone's incapable for, say, treatment, surgery for a broken leg. One, because I'm not the provider, so I can't fully outline the risks and benefits the way a orthopedic surgeon can. And the other is that the patient, one, has the right to talk to someone that is able to provide that information. And the other is that the laws with respect to mental health are different than related to general medical treatments. But in that situation, it's usually considered if the treatment is immediately medically necessary or not. So the Mental Health Act is the act that I fall under when making decisions about capacity.
No, unfortunately, there's so much stigma when it comes to mental health, Can you explain the difference between, Dr. Abate, the difference between a decision someone may not like or a decision due to inability to have capacity?
Right. So I'll use that case of a person that's hearing voices again. So I may say to them, they have, let's say they have other symptoms, they have paranoia, but there's no imminent safety risk. So I might say to them, my assessment is that you're suffering from a psychotic illness, and I think you would benefit from treatment with an antipsychotic medication. And I would go through the risks and benefits, the side effects of the medication, let them know of maybe a couple of different antipsychotics so that they could choose from them. And they may say, you know what? I actually, I'm okay with the voices. They say pleasant things to me and I'm doing fine. And I don't want that treatment. And that's their choice, because they're acknowledging their symptoms and they're saying, I appreciate what this medication can provide to me. I'm not interested. Versus a situation where someone is having those same symptoms, but is terrified for their life. They're barricading themselves in their home. Maybe they've stopped using water in their apartment because it's contaminated, or other things like that. And they're hoarding weapons and they're doing all of that. And I say to them, I think you're suffering from a psychotic illness, and there is a risk to others that's involved because of the way you're protecting yourself. And I understand that you feel this is real, but in fact, it's not. And I have concerns about what might happen if this continues. And they say to me, no, this is all real. I need to protect myself in that way. I would say to them, I find you my assessment is that you're incapable to make that decision. The risks are larger than you appreciate. And so we need to go through this route of finding you incapable and getting treatment on board.
Andrew, can you revoke a power of attorney? And if so, how can you do so?
Absolutely. You can revoke it as long as you've got capacity. And all you do is literally sign a document saying, I revoke the power of attorney. The law says it has to be signed in the same way that you signed the power of attorney, not the same people, but the same manner. And that means it's got to have two witnesses to it. So you simply would say, I, Andrew, revoke my power of attorney, and two people see me sign in the room at the same time, see me sign. And that revocation basically puts you back to ground zero. The challenge, of course, is that there are sometimes the people are kind of on the cusp of their capacity. Capacity isn't necessarily a black and white. You wake up one morning and you don't have capacity. Many times, Alzheimer's and dementia in particular, it's a gradual move towards incapacity. And when you're in that gray area, in that time near where you're losing your capacity, that's when sometimes paranoia, sometimes in particular with dementia, you think that the people that you've chosen are now out to get you. And so that's the real question, is when you're revoking it, do you have the capacity? Are you past that line to revoke it? But by law, it says you can do it. You're not locked in. As long as you have the ability to change your mind, you can change your mind.
So if someone is trying to exercise its right as a power of attorney to someone and contact your office pertaining to such, would you just believe the person's word for it, or do you require proof from a medical doctor or expert?
Well, I ask my clients when they sign the power of attorney, what do you want me to do when that time happens? So I get them in writing to tell me. So that I give them two choices. The first one is release it on the demand of the power of attorney. So that person walks in and says, trust me, mom's in the hospital, dad's in the hospital, she's lost her capacity. And my client told me to trust them. So I just hand over the document. The other choice my client has when they sign the document is I release it, but only when I have some medical evidence given to me that that person is incapable. So the attorney comes to me with something from Amanda, from the hospital, from someone saying, yes, dad's lost their capacity, I hand it over. That's a bit more of a protection for the client, a bit more onerous, it slows things down, but I become the gatekeeper.
So a quick yes or no answer, Andrew. Can the public guardian trustee overturn a power of attorney?
No.
No. Perfect. That's all the time we have for today's episode of Health 180 with Carrie and Fan on Rogers TV on podcast. Thank you to my guests for joining us today. Thank you to Caesar Chair Oshawa, and thank you for joining us. And remember, together we're stronger.
Call the Rogers TV viewer response line, email us, or connect with us on social media.